Why, thank you. Yeah, she made peanut butter cookies last night. I said, can you make any? She says, no, she was never a Girl Scout, but peanut butter cookies were good.
Yeah, they're just shortbread cookies. They are having cookie boost now. So.
Representative DeSimone.
Thank you for your indulgence, Mr. Chairman. I will sit down, shut up, and start right.
So you're the first bill, huh?
I am. So, yeah, so the
Oh dear. I'm opening the hearing on House Bill 1013 relative to amending the definition of temporary alimony. Since the prime sponsor is acting clerk, I will present House Bill 1013 and call on Representative Michael Vose to speak to this. He's got a committee meeting to go to, so I will call Representative up. He has written testimony, and I will pass it along. Please, in either direction, put testimony papers at the seats of those who are not here.
Thank you, Mr. Chairman, and good morning, members of the committee. For the record, I'm Representative Michael Vose. I represent Rockingham District 5, the town of Epping, and I'm here this morning to encourage the adoption of House Bill 1013. In my judgment, the current definition and statute of temporary alimony is seriously flawed and needs a major adjustment. I believe that this definition, this 23% formula for calculating temporary alimony, as currently written, doesn't take into consideration the marital obligation of both parties and their relative abilities to pay. Under these current rules for calculating temporary alimony, a lower earning spouse may be put at a significant disadvantage if the higher earning spouse abdicates his or her responsibility for marital assets, such as a house or other property, and or the maintenance of the family. Someone who will testify later on in this hearing will give you some concrete examples of the damage that's done by this inadequate formula for calculating temporary alimony. If you're the victim of an inappropriate application of this formula, fighting that decision can require the services of a lawyer and take time and money in a time of divorce, which is an emotional and financial stress for most people. Now, I believe that the committee can improve this bill. And in my written testimony, I've provided a written example of what an amendment, and I know I can't propose an amendment myself, but if an amendment were to be proposed, the language in my written testimony might be appropriate language. What
And
it
it
is
might be appropriate for somebody to craft such an amendment should someone agree and present it when we exec the bill on the 5th of March.
Exactly. And what would this suggested language do? It would essentially change the formula to a 50-50 formula instead of the 23% formula that exists today. Now, if you were going to submit an amendment to this bill, since this particular language that I've suggested in my written testimony only modifies the definition of the term temporary alimony, you may also want to look at other parts of RSA 458:19 to see if there are further adjustments to language that might be needed. So in conclusion, I urge the committee to address this serious concern to prevent future occurrences of, in the words of one of my constituents, quote, "A lower earning spouse is effectively abandoned, often with children and with limited financial resources, and she must choose between putting groceries on the table and hiring a lawyer for a long and drawn-out fight. And I thank you, Mr. Chair, for the opportunity to testify. I'd be happy to answer any questions if I can.
Representative McMahon.
Thank you, Mr. Chairman. Representative Vose, specific to your proposed amendment or the narrative to improve the bill, what's the definition of reasonable need in your guidance?
Reasonable need, I believe, would be a need that is fair and just to both parties.
Follow up, Mr. Chairman?
Follow up.
And relative to fair and justice, would that be a judge's decision then? And not an argument of, not an argument, but an advocacy of both parties justifying what their recommendation would be?
Yes, absolutely.
Thank you, Representative Vose.
Any other questions for Chairman Vose? Seeing none, thank you.
And thank you, Mr. Chairman.
Chair recognizes Patricia Davidson. The first requirement for giving testimony here is turn the mic on. And I say that politely because the last time I went to testify somewhere, they had to remind me. So, thank you.
Thank you, Mr. Chairman. My name is Patricia Davidson. I live in Epping, New Hampshire. I went through a divorce between December of 2019 and it was finalized in November of 2022. Has anybody here been through a divorce in New Hampshire? Was it contentious? All right. So there's no personal experience here.
The one giving testimony does not customarily ask questions
Sorry,
of
sir.
the committee.
Rhetorical then, perhaps. I'm very interested in this particular bill because my experience with it was very unequitable. There is no particular language in RSA 458 that describes how temporary alimony should be calculated. So in most cases, the judge will use the calculation for term alimony, which is the 23%. However, during the divorce process, spouses should be on equal financial footing. No one should be given an advantage over another. Given that the parties are still married, temporary alimony must take into consideration the marital obligations of the parties and their relative abilities to pay. Suggesting that the 23% formula for term alimony orders be used for calculating temporary alimony is inappropriate and unjust. Keep in mind that unlike for term alimony orders, during the divorce proceedings, an honorable party does not have access to assets, and the ruling for temporary alimony cannot be appealed. The 23% formula leaves the lower earning spouse at a significant disadvantage if the higher earning spouse is unscrupulous. It would be much more appropriate that the marital obligations be paid proportionally to income, or that the alimony be 50% of the difference in gross income as described in RSA 45819A, Part 2. The phrasing of the new text says that the court can find otherwise. However, that requires that the lower earning spouse hire a lawyer and have the time, energy, and financial resources to prove that 23% is inappropriate. That gives the higher earning spouse a significant advantage. They are also given the opportunity to leverage or force the lower earning spouse into an inequitable arrangement because the lower earning spouse cannot afford to pay the bills, let alone hire a lawyer. In my case, the judge applied the 23% difference in income formula for term alimony. That calculation gave me a temporary alimony amount of $2,303 a month. No consideration was given to the fact that my spouse moved away and left me with sole responsibility for all the household bills. After paying the mortgage and the property taxes, I had $173 a month left. That needed to cover utilities, care for 2 special needs pets, food, gas, etc. I could not appeal that ruling. Based on the financial affidavits that were filed with the court, this arrangement allowed my spouse to save $2,000 a month in an account from which he had removed my name. In addition to that $2,000 a month, he also had multiple voluntary deductions from his pay, including significant contributions to our retirement account. Luckily, I had a side business. I closed that business and found a part-time job so that I could leverage those assets to pay the bills, both household and legal. If I didn't have that business to liquidate and leverage, I would not have been able to afford a lawyer, and I would have to have accepted my spouse's final decree proposal. Because of the financial restraining order you are under during a divorce proceeding, I could not access my retirement accounts. I could not take out a home equity loan or a personal loan to bridge me until the divorce was final. While my spouse was socking away money and living his new life, I drained the assets I did have access to, wondering when they were going to run out. It was 34 months from when my husband left me to our divorce was final, and I finally did have to settle. That long duration is a direct result of my spouse not providing discovery documents and the multiple motions I had to file with him to comply. And during that time, he was spending marital funds in direct violation of the financial restraining order. It seemed to be an intentional tactic to drain me financially. If he had borne an equitable financial burden, I expect that that would not have been the case. Do not think that my situation is unique. I hear the stories, mostly from women in my divorce care and my runaway husband's support groups. The lower earning spouse is effectively abandoned, often with children with limited financial resources, and she has to choose between putting groceries on the table and hiring a lawyer for a long, drawn-out fight. Guess what she usually chooses? I was one of the lucky ones. I'm here today, and I had a business to liquidate. Again, temporary alimony orders must take into consideration the marital obligations of the parties, and they must put the spouses on an even financial footing during the course of the divorce. Anything else is inequitable and unjust.
Will you take questions?
Yes.
Because an amendment cannot be brought before a hearing, but winking and nudging can be, should perchance an amendment come to us that might include the words or a formula based on 50% of the difference between the parties' gross incomes at the time the order is created, would that be the kind of change you might wish?
That is the kind of change that I would like to see happen, yes.
Well, we just might get an amendment that says that. Who knows?
Thank you.
Any other questions? Seeing none, thank you so much for your testimony. And I was going to say we're calling up an old friend, but I don't use the word old. So what is the term we use here? Put your mic on for that, for the record.
Mr. Chairman, I offer an alternative strategy,
Yes.
and that's that you use aggressively mature.
We are bringing an aggressively mature veteran to this committee, one whom we've enjoyed before, Attorney Jay Markell.
Yes, thank you. Okay. I was distressed to hear the testimony from this woman. I'm very sorry for her plight. But let me first address the bill as proposed and why it's proposed the way it is. And I can understand the objections to it, but I think part of the objections to it come from perhaps an incomplete knowledge of what the law allows. And that's certainly important. First, I was involved in the original alimony reform initiatives and had competing bills back around 2017 when the state of New Hampshire decided that it needed to, when the Child and Family Law Committee initially decided to overhaul the alimony statute because it needed work. At the risk of being somewhat self-serving, the concept, the term alimony was actually mine. It was adopted by the court. By the committee. I had no objection to it. The original basis of that term came out of the Massachusetts Alimony Reform Act, which was before, and they used the general term alimony. So what I did was I abbreviated it and created the term alimony. Like I said, it was later adopted. The point here about using the current alimony formula brings it in conformity with the rest of the statute. Okay, the idea is that, I'm sorry if this is here, the idea behind the original alimony statute reform was that it would bring predictability to an alimony order, and you wouldn't be going into a court with a Wild West shoot 'em out. The reason why it's 23% was actually the result of two prior mistakes in the law that was actually adopted. The original alimony statute prior to reform had a provision in it which allowed a court to take into consideration the tax considerations of an alimony order, because at that point in time, alimony was both taxable as income to the recipient and tax deductible as an above the line adjustment to the payer. So that was an important tax consideration. It was omitted from the reform bill that they ordered, that ultimately became law, and the subsequent Tax Cuts and whatever act was federally of 2017 eliminated the deductibility as alimony. So the statute had a big hole in it. And the big hole was, if it's going to be 30% of somebody's income without consideration, which is what it was before the change. I think it was Senate Bill 71, which later amended this. And what it did was it took the 30% down to 23% in the event that it wasn't taxable, because 30% was considered frankly harsh. The other things that need to be considered, and by the way, so let me address this bill, and then if I can address the prior witness's testimony, I think it's important. First, so what this does is that this adds predictability to the statute. The whole point of the entire statute was to add predictability and be able, if you're a lawyer or anybody else, to be able to sit down with your client, or if you're acting self-represented, if you look at the statute, you'd be able to say to yourself, okay, this is how it's likely to play out, and this is what a court is likely to rule from. So if you bring temporary alimony in line, but nevertheless, the exception that's created in this bill specifically addresses a particular need. So when we look about using the formula, which is 23% currently, I'll speak into the microphone. Nevertheless, if you look, it's subject to the formula limits unless a party seeking temporary alimony pleads and the court finds that immediate irreparable economic harm would result if the percentage formula were applied, and the court makes specific findings. So what that does is, that's the safety valve that I think that the people were looking for. So if you've really got a significant economic problem that needs immediate addressing, okay, the court can simply vary from the formula. It's not that rigid. The other thing that I think so in other words, I think this will be good law. If I remember correctly, last year, or the year before, the committee actually passed it, and I think it passed pretty much as written through the House, and unfortunately got stopped in the Senate Judiciary Committee. So we're reintroducing it this year. The second thing to consider is, and by the way, I will repeat, I am very concerned about the prior witness's testimony. It felt like she was dealt with, it felt like she got the bad end of an economic decision. Perhaps a lawyer could have helped her. But let me explain this. First, in alimony considerations, alimony is predicated on need and ability to pay. So in other words, if one party has a need but the other party has no ability to pay, then it is unlikely that alimony is ordered. Now, bear in mind, the statute is quite comprehensive. You can find people to be voluntarily underemployed. If a court thinks you're hiding assets, or if a court thinks you're hiding income, it can attribute income to you under the terms of the present statute. So it doesn't necessarily have to be that percentage, number one. Number two, if you're left in a situation, alimony is not the only remedy you get in court. So, for example, in addition to alimony, a court can order a person who was financially able to pay bills in addition to alimony or in lieu of alimony or any combination of them. So in other words, you can say, You're getting an alimony payment. You're going to get this alimony, not only that, but in addition to which, I'm ordering you to pay. And then you name the bills: the mortgage, the insurance, the car payments, the telephone, whatever else it is. So there's a panoply of reliefs that are available to you if you're an aggrieved party. It's not that exclusive. It's not everything in alimony. Courts have that broad general authority. So this bill should stand as it would, and I know it's my opinion, and it has wide support, because this adds predictability to the statute, rather than have somebody just walk in and say, it's what I think it should be at this time. In other words, and what it does is it focuses the pleadings. So in other words, if you have, I'll repeat it, if you have some kind of immediate irreparable harm that can only be addressed in alimony, tell us what it is. You'll probably get the order. And that's all it is. I'd be happy to take any questions on point.
Any questions from the committee? Representative Bickford.
Thank you, Mr. Chairman. Thank you, Mr. Mark Cal.
Yes. Yes.
So it sounds like you want the bill to stand the way it is and be passed the way it is?
Yeah, I mean, the idea of having 50%, first of all, it's 50% of what? 50% of what? Of somebody else's total income? Bear in mind, if there are children involved in a case, as there frequently are, remember that that's in addition to child support. And by the way, in terms of the way term alimony is calculated, which is codified elsewhere in the alimony statute, is that child support is considered income to the obligor, to the obligee. I'm sorry, in other words, to the payee. So in other words, A and B, and A is asking B for alimony, and there are children. So B is ordered to pay child support and can be paid alimony in addition to child support, because they serve two completely different purposes. But as the New Hampshire Supreme Court found in Crow v. Crow, and I think that's back around 2005, more or less, was that that child support should be considered as income to the obligor, to the obligee, which is the person who's getting the child support. And the reason why is because they do benefit from it. You know, housing, whatever it is, and they do benefit from that. So,
Follow up.
sure,
Thank you,
Sure.
Mr. Chairman, Ms. Markel.
sure.
What is the 30%? I understood the part about the taxes coming out of it, so that's what made it 23. But
Right.
why 30% as opposed to 50%?
Well, that goes back. That goes back to the original bill that became law around 2018. I'll speak into the microphone. Around 2018. And the 30% figure in there was not something I created. It was created by another group of people. Okay, and the Child and Family Law Committee adopted it. The problem with the 30% was that supervening law from the tax code change eliminated the deductibility of alimony. So Senate Bill 71, I think it was, from probably 2019, had to go back in and correct that mistake, because 30% of a gross income could be punitive if you don't have to, if you're not allowed to deduct it from income. Okay, deduct it as an adjustment to income, which it was. Sub from the more than you might want to know department, it created that the federal tax reform created some initial problems as to what was going to happen with 2018 as to the deductibility of alimony. So there was this tremendous rush in 2017 and 18 to get all of these cases settled if you were going to be in an alimony situation, because after 2018, the deductibility of alimony disappeared. So in other words, you now had a case, you could not deduct it, and it was not an adjustment to income. Alimony served not only completely different purposes, but it was actually, the tax advantages made it strategically advantageous for both parties, depending on the circumstances. So for example, I'll give you more in the way of alimony based on the deductibility of the alimony payment, which is what it was, if we can do this and this and this. So both parties would get an advantage to some extent. Okay, so now alimony is basically in the same class as child support in terms of its tax advantage status.
Representative McMahon.
Thank you, Mr. Chairman. Attorney Markle, your clarification relative to what the bill is proposing is, just in quotes, it's temporary alimony.
Correct.
Okay, relative to where it states in here that it ends on the effective date of the divorce, but if there's children involved and still expenses of the other party, is there a different part of this bill that needs to be recognized for permanent alimony?
No, no. The way the bill currently works, the way the statute currently works is you have different classes of alimony. You have term alimony, which is the most popular one. You have some reimbursement alimony, and you have temporary alimony. Reimbursement alimony would be, it's generally not seen too much, but it was used in the past as a way of reimbursing somebody, for example, in lieu of a property settlement. Typically, it might be something along the lines, and I'll be stereotypical. One party puts the other party through medical school and works at a lower income job. The other party gets through medical school and now is a successful physician, and now successful physician decides the marriage is through. Well, what happens to the spouse who put that spouse through medical school? And that can be remedied in reimbursement alimony. That's one way to do it. As far as the rest of it goes, the rest of the language is okay. I mean, there are problems in the statute. First of all, we have if I can go beyond this, sir, in answering
I'd
your
rather you
question.
not, and just
Oh, okay.
focus specifically on what's before us.
Okay, I'm sorry.
Thank you. Sorry.
One follow-up,
Follow up?
and thank you for that. I'll take your class later.
Okay.
I'd like to learn more on this.
Okay.
The other question is, and this is for me, is what is, when it says on a proposed amendment versus what's in this bill, not in the bill, but refers to it, 23% of what? Is that of
It's the
gross
difference
revenue, net
between
revenue, or what?
It's the difference between adjusted incomes. Usually what courts ask for is an alimony worksheet. And unfortunately, it doesn't appear to me that the judiciary has created one that's put on a website. So most practitioners end up doing it on their own. And what you do is that they will take a gross income from each party, then they will make certain deductions. For example, who's paying for health care and who's doing this, and that will be create a deduction, and you can create an alimony worksheet. And then you can take 23% of the difference of their adjusted incomes, and that becomes the alimony order.
Councillor, wearing my other hat as chairman of the Special Committee on the Family Division of Circuit Court, could you shoot me a memo outlining what a recommendation from my committee might be to the judiciary regarding alimony worksheets?
Okay, I
Thank
can
you.
do that.
Any other questions? Representative Long.
Thank you, Mr. Chairman. Attorney Markle, I just wanted to be clear that you're saying that the bill has currently written is the way you like it?
With this one here?
Yeah.
Yeah, I wrote it.
Other than the proposed 50%?
Yeah, no, I wrote it, so.
Oh, okay.
Seeing no further questions, thank you for your testimony.
Thank you,
And
sir.
with that, I adjourn the hearing on House Bill 1013. I would suggest the prime sponsor with co-sponsors take note of the fact that we will be executing this bill on March 5th, and you may choose to bring in any amendments, or bring in an amendment if you wish. And so you've got a couple weeks to work on that. So thank you, one and all. Okay. Are you seat filling? No.
Representative Fox, and I'm going to be subbing for the exec session.
Which we call seat filling.
Oh, I'm sorry. Exec C.
Seat.
Yes.
Welcome. I open the hearing on House Bill 1192 relative to contempt actions in domestic relations matters. And I am going to ask if Representative DeSimone will present that to us. And yeah, I know. Would you like anyone else to do it? Okay. Vice Chairman Long, would you present Representative DeSimone's bill to us, please? And you can do it from right there, if you wish. Who are you speaking to? All of us? I'm jealous.
Thank you, Mr. Chairman. Good morning. I'll introduce House Bill 1192 FN relative to contempt actions in domestic relations matters.
And I have one card, and amazingly, it is Attorney Jay. Is it Markle or Markel? Markel.
I respond pretty much to anything, so.
Counselor, please come forward, and as a matter of grace, your microphone has been left on for you.
Oh, okay, thank you. I guess in terms of this bill, I hope everybody has the handout that was provided.
Which one in particular?
Well, there should be 4 to 5 pages, starting with the Bar News article, 2 statutes, domestic protocols for the family division in relation to protective orders and contempt, and there should be a copy of the number of case filings printed for 2023 from the New Hampshire Court. Okay, thank you. I guess as an opening statement here, the point of this bill is, I think there's a real need for this bill, and the primary purpose would be to ensure the even-handed administration of justice and to clarify some things that are out there that have been kind of murky for years, because the issue of contempt is an important one, and I don't think there's a lot of pro se's who really understand what it is, and there's a lot of court. And
I'm going to ask you to stop, please, because we, including me, have been distracted with passing papers out, and we missed. And what little I did hear of it sounded pretty good, so I bet the more of it, it'll be better yet. So
Okay.
could you just hang on for 1
sure.
second, please?
Sure, no problem, sir.
Do you have 2 of everything that came by? Okay, good, thank you. Okay. Are we good, everybody? Up. One more second. We're good. Counselor,
thank
please
you.
start over.
Okay, thank you. Well, my name is Jay Markel. I'm an attorney in New Hampshire, and I've been practicing family law as a career changer now I've been admitted since 1998. So I've been practicing law for a while with a concentration in family law. And this bill deals with codifying what a contempt is and making the law fairer, simpler, and easier to understand, because we have so many people who are self-represented. I think it's instructive first to understand the history of contempt. And if you look at a New Hampshire Bar News article, which is top there, it was authored, I authored this, and it deals with the history of it to give some background. It's an old concept, and it really goes back to the King of England. The Anglo-American history of contempt is such that it goes back to the earliest references that I could find in law review articles was actually to a Shakespearean play in 1547. It ultimately became an offense in the Anglo-American tradition was actually an offense. If you disrespected the king, you were actually disrespecting the courts, because the courts were representative of the king. So if you didn't follow court's orders, okay, you were disrespecting the king. And then the remedies from that flowed. It could be anything from incarceration all the way through. So I provide that for a brief reference, and it also provides an article for you to review to get the idea what statutory standards should be. Now, when you look at the bill, when you look at it, there's a number of different things to talk about. And in the family law context, this bill deals with a wide sweep. What it does is it deals with all of the family, all the matters that come within the jurisdiction of RSA 490-2 D2, which is jurisdiction. So it not only comes in with divorce, annulity, custody of children, actions for support, abuse and neglect hearings, DVP issues, RSA 173B, which I'm sure we're all familiar with, adoption. So it is universally applicable. And when you look at the bill, just want to make sure I've got it out here to review it. What it says is basically, it defines what a contempt of court means. It means that you have to have an undoubted and willful disobedience of a valid, unequivocal court order. So these are key things, okay? And it has, okay, now, and by the way, I don't invent this. This is New Hampshire case law, okay? So actually, none of what's being offered here is revolutionary or new or untested. This is all well-settled stuff. So when you look at it, willful in the context means a failure to act, means an act or failure to act that is voluntary and intentional and not accidental. So it doesn't even necessarily have to be malicious, okay? It can be, but it doesn't have to be. And so when you look, and when we look at Section 2, we're talking about how these things are enforced. And that's going to be enforcement on abuse, alimony, all the child support and everything else within RSA 490D2. Now, we talk about where the burden of proof is. The burden of proof is going to be on the party seeking the enforcement by a preponderance of the evidence. Preponderance of the evidence means simply more likely than not. It's you've got the ball over the net. And if you don't have just cause as a defense for why you didn't obey the order, the court may award reasonable costs and attorney's fees to the prevailing party. Okay. Now, and here's a point which I think some people may misunderstand. We're talking about here order the incarceration of a contemner until such time as the contemner complies with the court's order. And let's deal with this. It's an extraordinary remedy. It's one that doesn't happen too often. Typically, you see it in willful refusals. And like I said, it doesn't happen too often, but nevertheless, people do need to know that it's out there because it just is. And typically that doesn't happen. But for example, in Massachusetts, when you're served with a complaint summons for contempt, it's noticed right then and there that you may be incarcerated. So what this does is that the intent here is to provide notice for any potential contemner, and they're out there, that you could go to jail for something like this. It's possible. So this is notice. Where is it typically used? Willful refusal to obey a court order. I'll give you one example. I had a case where we had subpoenaed somebody in for child support records, and the party simply refused, was behind on his child support, had a lengthy criminal record. Turns out his girlfriend was working for the company that he was working for. We subpoenaed their records, and it turns out his girlfriend was the keeper of the records. And they would refuse to provide the records. Now, bear in mind, this was the same organization that we had successfully subpoenaed records for in the past on a different case. We brought it to the attention of the court. The court ordered a subpoena ad testificandum ducis tecum, which is legal gobbledygook for you're coming into court, you're bringing the records, and you're going to testify. Okay, and in there was a note that you may be put on for a show cause hearing if you refuse to comply. Show cause is the step before incarceration, And what it does is basically, you're going to have to tell us why we shouldn't order you to be incarcerated. Okay? So incarceration may result. And I don't want you to think that this is fostering people going to jail. It almost never happens in New Hampshire, but it's possible. So when we look at it, and nothing in this section shall be construed to limit or preclude any other rights, comma, remedies, comma, or causes of action that may exist under any other statute. So when you look at contempt, there are different forms of contempt and there are different remedies. So the court has a wide variety of remedies that it can impose. So why should we do this? Okay. A, people really need to know how to plead these cases. Judges really need to know standards and guidance as to what they should be using in the way of doing it. It makes, from the judicial standpoint, it makes writing your findings of fact much easier, because all you have to do is look at the case, look at the statute, and you can apply the facts as to why a person is in contempt or isn't in contempt. And then what the possible remedy is going to be. One of the things that I had noticed here was that the judiciary had weighed in, and it says that it thinks the cost of incarceration may be a consideration. I can tell you that in my research, I have not seen any time that the cost of, that if a court was seriously considering incarcerating an individual, that the cost of incarceration was actually a consideration. Not in 500 years if I've seen that, if a court is considering putting you in jail. Now, bear in mind also in your handout, you will see Chapter 10, which is violations of protective orders and contempt. Now, these are not binding. They come out of the New Hampshire Rules of Court from the Family Division. And when you look at it, you will see here that there's a couple of issues that I have to deal with. While these might be considered best practices, they create schisms. I'll explain to you what I mean. First, it talks about jurisdiction, and it talks about the types of contempt, and the types of contempt which are civil contempt, which is what this would be. And what it talks about here, it does not in any way, shape, or form reference a court to consider whether or not there's going to be a cost of incarceration. It would seem that if the judiciary were considered it to be that serious, it would have been included certainly in the protocols. It's simply not. The other issues that I see with the present protocols are that they create two completely different standards. If you look, for example, on, let's see where it is, the standard of proof used under the protocols, what they're asking you to do is use a clear and convincing evidence standard, but only for two things: violation of parenting and domestic violence petition. Okay? So people who don't pay their child support don't get that benefit. In other words, you're actually making it harder to prove a contempt, okay, and giving more due process protection to somebody who violates a court order in terms of domestic violence, which may have more serious consequences than somebody who willfully refuses to pay a child support. Now, bear in mind, the overwhelming majority of research that I've looked at establishes civil contempt, which is different from criminal contempt. And criminal contempt is not a part of this statute. It's preponderance of the evidence is the generally accepted standard. So there's a dichotomy here. And finally, two more key points. Number one, when we look, if you look at the statute presently that's in place, it's RSA 458-51, attorney's fees and contempt of court cases. It should be included in the handout. What it does is that it says, okay, if one party can prove the other party is in contempt, the court shall award attorney's fees. But unfortunately, the statute is absolutely blank on what constitutes a contempt. So we don't have that here. So why wouldn't we add that and put that in so everybody can see what it is? And one of the other things that I think is worth looking at is how important is this? Well, if you look at a chart published by the New Hampshire Judicial Branch that's included here, is how many cases that were in 2023. And if you look at it from all the various filings, adoption, surrender, domestic matters, domestic violence, and all the way through, you're going to see that there were total filings of 15,155 cases for 2023. That's a lot of filings, in my opinion, for a state as small as we are. And so, sorry? Okay, it's on the handout. It's 15,155 cases were filed of varying types in domestic relations matters last year. So and just common sense says that contempts are going to be an issue, at least contemplated, in almost any case. Somebody's going to be thinking about it and somebody's going to be filing it. So this is not merely an isolated or inconsequential issue. This will deal with a significant portion of family law cases, in my opinion. The one thing I was not able to find out from the judiciary was how many contempt actions are actually filed. They're listed here, okay? Or how many motions for a contempt are actually filed during a case while it's in progress, which is typically what happens. The one change that this bill makes from the current statute is that the current statute says that a court shall award attorney's fees. The proposed bill says that the court may award attorney's fees. I'm respectfully suggesting that I think we need that discretion for a court to be able to determine whether the conduct is egregious enough, okay, given the standards that are provided. I think that's important. And what it does is, and finally, what it does is that it not only improves the administration of justice, but what it does is that it allows parties to effectively argue their case. You can say, one party says the other party's in contempt because, and the other party can stand up and say, I'm not in contempt because, and then the court decides, because these are basically factual inquiries.
Any questions? Representative Long.
Thank you, Mr. Chairman. Thank you, Attorney Michael.
Yes, sir.
For parties that are financially strapped,
Right.
would this better get them an attorney representation, knowing the possibility of reimbursement? So if I had no money to get an attorney, the answer would be no, I don't have an attorney.
Right.
The fact that the potential reimbursement, would I be able to, would more attorneys be more apt to represent people knowing that there's a potential for a reimbursement?
I don't think it goes one way or the other. And the reason why I don't think it does is because there's such a very high percentage of people who are self-represented. I don't think attorneys take cases necessarily because they think they're going to get attorney's fees in family law. Okay. There's a difference, and you certainly can't take it on a percentage basis for the most part. What it does is that it allows the court the discretion because and I think it's necessary. I'm trying to answer your question.
Yeah, no, you did. I have a follow-up.
Follow-up.
So that a higher percentage is pro se, so there would be no
Right.
reimbursement.
There's no attorney's fees then.
And one more follow-up, if I may.
One more follow-up.
Now, you mentioned you recommend keeping it at May, let the judge decide if it's egregious enough.
Yes.
Sitting on this committee for years and hearing from the family court committee, it seems like judges give a lenience for, I'll let you do it once, I'll let you do it twice, maybe. So that's why I'm wondering if the shall would work. In my opinion, I'm seeing judges with a lot of leniency. So even though something may be egregious, maybe not that bad, the may give, may give a break.
You could certainly.
Do you see that?
Yeah, I can understand it. I would certainly be amenable to an amendment if it wanted to retain that piece of the present statute. I think that would be fine. My only concern was allowing judicial discretion because they can fine you in contempt. They can order you to pay a variety of things. They have broad discretion as to the remedies they can fashion for somebody who's found in contempt. And that's why I said may, not shall. The question is, how far does it go? That's why it was there.
Good, great. Thank you.
Any other questions? Yes, Representative Gregg. Representative Grossman, I'm getting there. I'm working through the Gs. Thank you.
Thank you, Chairman Pearson. Thank you for coming before us. So what are the current remedies that are being used for contempt? And so you're saying that this helps define contempt, and what are the current ways that if someone is in contempt, it's at the judge's discretion, there's not?
Right. Well, typically the remedy is order compliance. Okay, I now order you to comply, and if you don't, I'm finding you in contempt, and now if I don't order you to comply, I'll put it on for show cause. Okay, so that's one way of doing it. Show cause is you're in contempt now, okay, and if you do this again, you're going to be in show. I'll put it on for a show cause. That means we're going to put you. You got a real good shot of going to jail if you're not complying with my order. That's the way it would be. The other remedies can be as wide as the situation requires. It can be additional parenting time for somebody who's withholding parenting. That's why we say we don't paint anybody into a corner on this. Nothing precludes any other rights or remedies. So nobody's painted into a corner. I hope I'm answering your question. If I'm not, oh, okay.
Representative Bickford.
Thank you, Mr. Chairman. Thank you again.
Sure.
So what we're looking at is, it's in case law,
Right,
with the exception of the not.
right.
And you want to have it codified so it will be more available to the, as you said, pro se, which is the
Right.
people representing themselves.
Correct.
Thank you.
Yeah. The idea here is that the average pro se isn't going to be on the case law websites looking this stuff up. They're not going to have access to that. Even if they type in contempt of court, they're not going to know what the elements are. And so this would give somebody cause for pause, because you can click on a website, you can go right to the statutes, and you can find out whether or not you have a case for contempt or whether or not I better not, because they will have a case for contempt. And so people can frame their pleadings. And like I said before, judges can now look at it. Here are the facts. Here's the law. The other thing that helps judges is when you read narratives, they have no place to go. This is the really weird part. Judges actually have to cut and paste their findings on their narratives. So in other words, I look at it and I look at the narratives and it says in contempt for, and then it'd be state v. not. In contempt because of this, this, and this, and they actually have to cite case law. Now all you have to do, instead of cut and paste like that to put your narratives together, all you really have to do is just look at the statute and say bang.
Thank you so much. And before you
Thank you.
go, when it
Yes,
says
sir.
and other remedies, that no longer includes banishment to Australia, does it?
No, it doesn't.
Okay, that died in the Atlantic on the way over.
Yeah.
Thank you.
Yeah. Okay, thank you, sir. And I thank the committee.
And council was presenting for the prime sponsor as well, because you've worked this out. Now we go into our 3-minute drill. Testimony confined to 3 minutes, and veterans of this committee will know that you can say your point very well in 3 minutes. The chair recognizes Katrina Heinrich from Exeter to testify. Yepper.
I think I provided testimony enough for everybody, but I do have an extra if somebody needs it.
And we start.
I am Katrina Heinrich, and I wanted to speak to this bill, not in necessarily a total opposition, but some clarification, just because there is such a high self-representation that occurs. So transparency and understanding of the laws is definitely difficult for a lot of people. Some of the issues I wanted to address was considering what is a valid court order? What makes it a valid court order? You look at the U.S. Code of Title 28, 636. It talks about the jurisdiction and powers of what in our state, a master does or a magistrate. Orders from the family court, as we know, because we have a special committee, may have attributes that perhaps improperly reflect what a valid order is. So I reference to the 2007 New Hampshire Supreme Court ruling that talks about how marital masters are authorized to make recommendations, which, though they're normally approved, they have no binding force upon the court. They are not judicial officers according to our own state. Stakeholder testimony has reflected that such orders are not signed frequently, if not consistently. And that's gone over the years. We've gone back in testimony from critical stakeholders. So looking at that, there's a possible conflict there. I think that needs kind of sought out a little bit more as to what the details and actuality of what a valid court order is for all these self-representations. And then there's also the concern that has come forward about consent. Whether in our family courts, the marital masters are actually getting consent as required under Rule 73 in the Code 636. There's some other issues concerning the hearings, that they have to be conducted by a district judge upon certification of the facts. And again, there seems to be a little conflict in what we actually do versus what we're supposed to be doing. And then the final thing I'll draw attention to is the preponderance of the evidence piece. There seems to be a large arbitrary and a lot of testimony to the arbitrariness of this and the rules of evidence and how they are or are not applied. And overall, the bill is a mechanism to deliver consequences upon domestic relation litigants resulting from these orders. It just seems prudence to really dive into what is a valid court order. Are we actually putting out valid court orders according to both federal and state law? I think a clear understanding for court litigants, is important, as it is for legislators, to understand what litigants go throughout this process. And that is really what I wanted to draw your attentions to.
Thank you. With 30 seconds to spare, anyone with a question from the committee? Seeing none, thank you for your testimony.
You are welcome.
Chair recognizes Dana Albrecht, who has a lot of stuff to give us. That's not a technical term, by the way. It says you have 18 copies of 4 exhibits.
Well, there's only 4 handouts, and I wanted to make sure you had enough copies of the 4 handouts.
Well, thank you so much. 3 minutes starts now.
Well, so good morning, Mr. Chairman and members of the committee. Again, Dana Albrecht, Nashua, New Hampshire, and I'm a father of 4. As a very brief background, I think that one of the many things that went wrong in my family law case is that my parenting plan was never followed. So I'm sympathetic to what I believe are some good intentions in this bill. With that said, I'm very concerned about certain specific language and possible unintended consequences. So rather than be for or against this, it's my hope I can give you a little constructive feedback that's hopefully valuable and relevant. So with that said, if we can address specific language in the bill itself. So I think one of the things we're trying to do is spell out specifically what stuff means, and that's a laudable goal. So I suppose I'm one of those confused pro se litigants We heard from Attorney Markle earlier, and I'm confused about what a valid and unequivocal court order really means. So one of your handouts is a one-pager that says it's a list of judges in the NH Circuit Court. And on that, you'll see judges, but you'll also see a per diem marital master. You'll see senior active judges. You'll see judicial referees, also known as retired judges. And you'll see referees that are attorneys appointed per RSA 490 F5. And as a second handout, if you look at what the First Circuit Federal Court of Appeals decided in Witt v. Justices of New Hampshire, it says that masters have no inherent power, but rather derive all their power from the appointing judge or the agreement of the parties. So my first question is how, whether, and under what circumstances do the actions of the per diem active senior retired judges, referees, appointed attorneys count as a valid and unequivocal court order per this proposed statute? So if you kind of compare the Witt opinion from the Federal First Circuit Court to an email written to me on February 15th, 2022, so that's the third handout, by a judge in my case. She writes to me that she suspects she was a co-signer. Well, what exactly is a co-signer and what's the legal definition of that term? And she also says she didn't make any decisions in my case substantively. So what does that mean? Confused pro se litigant. Do we need something in this bill about the difference between a decision that's made, substantively versus one that's not? Because are non-substantive decisions valid and unequivocal court orders or not? If you also hand out 4, which is just a transcript from Administrative Judge King on August 26, 22, he talks about cosign or cosigned on page 9. So
You've got a half a minute.
So you can see that on the second to the last page. That's the corrections page. So again, cosign or cosign. I think you said you owed me 30 seconds last time.
I did. You're in the bank. Go.
Okay. I think that's critical because when you get to section 4 of the bill itself, it just says the court. Well, what part of the court? Does that include attorneys appointed at will that the Federal First Circuit says have no inherent power? Does 4A mean attorneys with no inherent power can force litigants to pay fees to other attorneys? Does that mean pro se parties paying fees to represented parties? And when we get to 4B, does that mean attorneys with no inherent power can incarcerate people? For how long? Until such time as the contemptor complies, mean indefinitely? What if the contempt's for not paying attorney fees?
Will you take questions? And by the way, for the record, you owe me 9 seconds next time. Okay. For anyone with a question for Mr. Albrecht? This includes the temps and Representative Long, yeah, right next to me.
Thank you, Mr. Chairman.
Yes.
Just for clarification, so what constitute a valid court order was 1. Do masters and other judgings qualify under this?
Yes.
Was 2. And pro se paying fees?
Yes.
3. Was there another one?
Yes. So incarceration, and I just say that's a pretty wide sweep.
Okay, thank you.
Any further questions? Seeing none, thank you so much.
Thank you.
The chair recognizes Susan Brisson. Is that attorney Susan? It was last time, right? Yeah, it still is. Okay. No disbarment.
Good morning. I'm Susan Brisson. I'm the Chief Staff Attorney for the Office of Child Support. Our office is against this bill, mostly because I think it's not necessary. Most of what it covers is already in case law. I would also point out that there is in the Family Division Court rules, looking at Rule 2.31, Enforcement of Court Order, it talks about bringing a contempt action in an open case and bringing a contempt action in a closed case. It even mentions that there is a motion for contempt, a standard motion that you can get off the website for the court, which they just have to fill out. So it's not that somebody who's searching for this remedy has to create a pleading out of thin air. One other thing I pointing out, and this is because my brain likes completeness, is if the bill was going to go forward, I would suggest an amendment with regards to starting in paragraph Roman numeral 4 with regards to attorney's costs and incarceration. I would suggest that there should be a C for anything other that the court would deem to be equitable. Because right now it's just you can get attorney's fees or you can put somebody in jail. Seems to me the court should have the ability to craft some other remedies as is necessary depending on the case.
Any questions? Yes, seat filler Colcom.
Thank you, Mr. Chairman.
My Irish wife would be very upset I didn't pronounce that correctly. Colcom.
I'm not sure that it's an Irish name, so
Will not tell my wife in any case. Thank you.
you get a pass. Thank you for taking my question. You mentioned case law. Can you explain to me the difference between our statute law and case law and how the case law would prevail over our statute?
Oh, that's a difficult question. Case law is usually used to fill in. The statute comes first. In that, and I think listening to Mr. Markel's testimony that he wasn't meaning to really change the law, he was just meaning to put it all in one place, as opposed to case law. Sometimes when you read it is a little bit here, a little bit there, a little bit there, and you have to sort of amalgamize it together. So it's an attempt. This is an attempt to sort of put it all in one place so that everybody can go, oh, this is what you have to do, and not look in 16 places. Mm-hmm.
Working on a few items in the Rules of Evidence book with members of the judiciary where there is case law that's a bit squiffy, we're concluding that sometimes putting it actually in statute makes it clearer, even if some would say it's clear in case law. Would you agree? I would agree. Thank you. And I think that that's the legislature's meant to be the top of the three branches. So legislation would come first. Your colleagues in the judiciary agree, so I'm still on this project with them. Any other questions? Representative Bickford.
Thank you, Mr. Chair, and thank you, Ms. Brisson. You mentioned about an amendment, and I didn't catch it all. It was something about other remedies, I think. Could you point out exactly where that should go? And if you don't want to do it now, I'll take it later.
Well, sure. It's in Roman numeral 4. It's talking about if a party alleges and the court finds that a party is in contempt, it goes on to list what the remedies that the court may award costs and attorney's fees, order the incarceration of the contemnor. I would suggest that C allow other remedies as the court may deem to be equitable.
Thank you.
Anyone else? Thank you so much for your testimony, Counselor. And this concludes the hearing on House Bill 1192 with Representative DeSimone as principal sponsor and Representative Nelson and Seidel from this committee. Perhaps, if they wish, they may bring forth an amendment. We will be execing this on the 5th of March, and we will recess for about as long as it takes for the clerks to swap positions. And thank you so much. We have 2 clerks here and now an adjunct veteran clerk. Thank you for your help. Sure.
Excuse me, Mr. Chairman. Excuse. Hi. Respectfully, a couple of us need to maybe have a 3-minute break before. Would that be possible to use the restroom? Okay.
We've always known it as English, but we don't have much history on my husband's family, so it's been nice to know.
Well, the Pearsons from so far north, depending on who won the last skirmish, we could stop and go.
I believe Ellis Island, but I have not been able to find anything beyond that time. So we know nothing more about his family.
We got our back to. And such success should inculcate humility, because although we have our saints in open, all those students. Okay, he's doing research.
That'd be great.
Okay, well, the ones that don't return to.
If we behave,
What else?
We're gonna switch spots on you, Chairman, one day.
Yep. Make you keep guessing. Be like a parent trap.
You're here for Gibbons?
Thanks for being here.
This is a pretty, I think, an interesting committee. Yes, very much.
Oh, good. Okay, good. Now I have a clear mind. I'm not worried about getting my
Same nail color. You and I do that a lot. Notice that? Like, it's not a color I normally wear, but I thought it
Me
was black,
too.
and it was a
HES between England and Wales, so it is a Welsh Celtic derivation.
Can you spell your name, ma'am? C-O-L, C-O-M-B-E. So you said English March?
Marches, which is kind of a border territory that goes back and forth. They often refer to that as marshes, but not with an S. It's not necessarily wet. It's just borderland. My people come from the English-Scottish marshes back and forth, which makes things very confusing.
Right.
Well, that's where you go start.
I think we do the same thing. I'd like to have it on, yeah. Yeah.
No,
It is,
no,
rather
he
than,
is
like,
doing it
rifling
for ball.
through. Yes.
Drew Fox is a Democrat, right?
Yeah.
Drew, D-R-U, Fox, F-O-X, is subbing for Gibbons.
Right, and who's this gentleman?
Connor.
The clerks, plural, would like to know your name. He needs to know it too. This is Jim Connor.
Jim Connor, Representative James Connor.
Panic.
Open the executive session now on House Bill 1261 relative to voluntary services under the CHINS program. And this is an exec session. We got to vote on this. So no one testifies with the rare exception of when the chair deems an expert is needed simply to clarify things. So I'm sure we've discussed this in our various caucuses, and here we go. So who'd like to talk about this? Representative DeSimone.
Thank you, Mr. Chairman. Years ago, we already dealt with this situation in CHINS, and I'm not sure passing this legislation will make it better.
Okay. Anyone else?
Just, have you motioned it, or am I missing something?
No, we're just discussing it.
One more statement.
One more statement.
When I did ask legal counsel if it was necessary, it was explained that it's already in statute.
The DCYF General Counsel
Correct.
knew, Susan Larrabee, said that the bill is unnecessary.
Correct.
Lissa Marcio, who I like, and she's sitting over there, said,
It really
you like
would,
it, but did you say it was necessary? Now we know. Okay, thank you.
I think it would muddy the waters and make things bad. So I'm going to agree with counsel and agree that this is not necessary.
Anybody else on this bill? Would you like to make a motion?
I would love to make a motion.
You'd love to, not just like, but love.
ITL on House Bill 1261.
ITL, and that's DeSimone. And in my bipartisan way, is there a Democrat who would like to second that? You are indeed a Democrat. Representative Long seconds it. Any further discussion? Seeing none? When the clerk is ready, please call the roll. The motion is ITL.
Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford, Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Connor,
Yes.
Representative Colcom,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrina will vote yes. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Fox,
Yes.
Representative Raymond,
Yes.
16-0.
Now, what question do people like to ask at this point?
Consent?
Yes. Any objection? And what statement does the chair like to make at this time? It's on consent. Yeah, that was the question we answered. What's the statement I make at this point? Committee report.
Working on it right now,
And when is it due by?
in about 5 minutes,
Well, yeah. And where does it go first?
to you.
Thank you. Well, we've got everybody here. I have been, oh, by the way, this concludes the exec session on 1261. While I've got everybody here, we've been doing some back and forth. I've given people a chance in the committee to volunteer to do speeches and PIs, and you never know if a bill's coming off consent, so you want to be ready. Probably the worst preparation was a time in my first year when the chairman didn't know the bill was coming off consent and wanted me to give the PI, and I walked up and said, "Hey, what's the bill?" And so he told me, and my PI was, "Mr. Speaker, if I know that the people voting for this bill really were smart, would I not vote for it too?" And I hadn't a clue what the bill was. So we want to be better prepared than that. So here's what I've got. On consent calendar 1027, Representative Perez, be ready to give a speech, and you can pick your languages amongst English, Spanish, or Portuguese. Thank you. And the PI to Representative Gregg. 1341, the speech, Representative Bickford. The PI to Representative Grossman. 1511, the speech, the prime sponsor, Representative Hobson. I will give the PI, or I'll be ready to. 1590, the speech, Representative Long. The PI, Jody Nelson. 1667, the speech, and the PI, me. Regular calendar. Representative DeSimone, have we figured out yet which bill it is you're thinking about coming back to committee? Is it 1111 or his other one?
It's Representative Spillane's bill on, excuse me? No, the other one.
1111 of
The reporting of arrears in,
1189.
I don't think it's on the calendar yet.
No.
1111 is on the calendar. The other one isn't.
It's the other one with reporting the arrears on child support.
1189.
That's 1189, and that's not on the calendar. We're going to exec that on 3-5, so we can certainly have a big, long discussion on it.
Okay, on 3-5, 1189.
Yep, okay.
That's the one.
Now, 1111, giving the speech is Representative Spillane, and the PI is DeSimone. Who, huh? You. You can call the clerk's office and ask to be on the speaker's list. That'd be good. That doesn't come from me. That will come from you directly to the clerk. And if there's any questions, just have them call me and I'll say it's certainly fine. But it'll be good. Okay. 1282, the speech, Representative Ball, who is not here, and the PI, Representative Gregg, who is here. 1425, the speech by Representative Raymond, and the PI by Representative Nelson. 1564, the speech, Representative DeSimone, and the PI by Representative Long. 1564. And 1573 with the committee amendment. Since I ran point on all of this, I'll do speech in PI. 1595, the speech, Representative Maggiore, and the PI is Bickford. So, what's that? Is it now? Yes, it is indeed. I will make that change. Thank you. All right, we're good. Next on your list is 1269. That's a mistake. We're not going to be executing that today because there have been a flurry of conversations taking place with the prime sponsor, McGew. Okay, there's letters missing in there. So we're not ready. And so he asked, could we do it on 3-5, and we will. So there's that. Yes. 1573. Yeah. I'm doing both. Thank you. So we've taken care of 1261. All right. I open the executive session on House Bill 1659 FN, Representative Post's bill relative to interference with child custody and shared parenting. Anybody want to speak to this?
Mr. Chair?
Yes.
In discussing this 1659 relative to the parenting, if a child is taken from his or her parent for 2 years and brought back to the other parent, are we going to punish that child by not allowing that child to see the former parent because the former parent did the wrong thing? Are we punishing the child? I just think that this bill could be amended to remove that language, and then I would go on to where it says within a 2-year period. 2 years is a long time to wait to rectify a situation. I would like to see it amended to 30 days. So I would like to ask Mr. Chairman if we could recess the executive session on this bill so that I and anyone else who would like to can sit with Representative Post and talk to Representative Post about an amendment.
And it is your intention that we would then finish the executive session on the 5th of March? We
Yes.
would postpone that from today
Yes.
until that 2 weeks?
Yes.
I believe that is allowable. Representative Gregg?
Thank you, Mr. Chairman. We do have another bill that was prime sponsored by Representative Kutab that really does cover a lot of this, but doesn't have that punitive aspect where it's using the child more as like a pawn, so to speak, or as a chess piece in this. So there is another. I don't want to duplicate bills. We do have one that's incredibly similar that has already passed through this committee. So I would like to look at that and make sure that we're not, because if we amend this particular bill, we're going to be like in step with this other one. So I really don't know if that's necessary on this. Thank you.
And for clarification, this bill has passed through this committee already? Okay, we'll get back to you. Representative Bickford.
Thank you, Mr. Chairman. As far as Representative DeSimone's points, the 2 years is so you can have time to not have to squish all the time all at once for the other parent. So the courts have plenty of time to do that. So I think it's appropriate the way it is. We need to leave discretion for the courts as to how they want to fit that into both parents' time.
Your point being on line 18, it doesn't say at the second anniversary, it said on or before it.
Right,
So it could be a year, it could be 6 months.
right.
Okay. Representative Gregg.
Thank you, Mr. Chairman. Thank you for giving me time to look that up. So it was House Bill 1006 with Amendment 0448, and it was passed through committee unanimously
And
2 weeks
it's-
ago.
And it's, yeah, my short-term memory being what it is, okay? And you believe that 1006 adequately addresses the concern without some of the possible negatives?
Without the extensive punitive damage that I think would be more harmful to families than helpful, yes.
Okay, anybody else? So are we moving towards a motion of ITL? Does it sound that way? Thumbs? before we make an official motion that we may regret? Okay, how many think we should go forward with this bill OTP? That's not a thumb, that's an index finger. And she's not. Well then, Representative Gregg, would you like to make a motion and write the report and
Wait,
have us rise up and thank you?
Mr. Chair, you didn't.
Yes.
We didn't answer Representative DeSimone's question of, you didn't ask about that. To wait? You said either OTP or ITL.
Okay,
But what about the third option?
thank you very much. How many of you would like to wait 2 weeks? 1, 2, 3, 4. All right, since that's not official, what amendment might be brought forth in 2 weeks? So those of you who are thinking of an amendment in 2 weeks, what do you got that the others might either be mollified by or not? I know you're doing some research there, yeah.
I was.
Yeah.
I just would like to do a side-by-side with Representative Katab's bill and Representative Post's bill and work with Representative Post to make sure that her issues are being addressed in the Katab bill, and the Katab issues are only going to be enhanced by the Post bill. Before I vote one way or the other on the Post bill.
Anybody object to holding our horses for 2 weeks? Could we have I'm not sure if we need a motion. Can it be just a request of the chair that we postpone 2 weeks?
I believe, Mr. Chair, you can recess until March 5th.
Until when?
Until March 5th.
March 5th. Okay, the chair so orders. We will recess this for until 3/5. Thank you. That
Thank
ends-
you for the indulgence of the committee and Mr. Chair.
Oh, thank the committee for their indulgence. Former acting clerk. And then we've got the answer to this. We can do side by sides and you can craft what you wish and be ready. The chair now opens the exec session on CACR 17. And you will remember that I fantasized a great committee coming together to try to meld the two into 17 plus 25 divided by 2, and that never happened. That just plain didn't happen. We didn't get to it. Apologies. So we start with CACR 17 on the rights of parents. That primary sponsor is Representative Cordelli, who is here in case there's technical questions. So we're opening that hearing on CACR 17. We will have a hearing on 25 shortly. And what would anybody like to share with the committee on this? CACR 17. And you can make comparisons to 25 if you wish, because both are in play. Representative DeSimone.
Thank you, Mr. Chair. I think that reading both of the CACRs and going over the content of both, CACR 17 seems to address the parental rights and protect the children at the same time. I think they're both well thought out. I applaud both of the sponsors. I'm just more amenable to the fact that CACR 17, that is the
Representative Cordelli, CACR. I think it's more complete. It takes more of the fundamental rights into consideration, and I'm just more comfortable with it.
Okay. Anybody else? Yes, Representative Long.
Thank you, Mr. Chairman. Couple things. One is last year we had this battle on the House floor. That's one thing. The pertaining to 17, the on lines 7 and 8, would end life or otherwise physically harm a child. I'm thinking psychological or emotional, which testimony we were told that those would still apply. Speaking with attorneys, they're not together with those statutes still applying. So that's one issue I have with that. And also direct to insert on number 3, starting on 11, direct to insert in their warrants. Municipalities don't have warrants.
Where are you?
On line 11.
Line 11, okay.
Yeah, number 3. To add this question via warrants. I know there's a statute that sort of brings that all together with respect to references of city and towns, but I don't know if warrants if warrants are addressed in that.
Okay, thank you. The prime sponsor's out of the room, taking a phone call. Anybody else? Representative Petrino.
Thank you, Mr. Chairman. Mr. Chairman, every time a parental bill of rights comes up, I always ask the question, do parental rights already exist? And the answer that I get again and again and again is that, in fact, they do. The problem I have with this bill and all parental rights bills is it gives a false impression to the public that they do not have parental rights, when in fact they do. I think it's a bit deceptive. When parents feel that their rights, the rights that they have been violated, it would be better for us to direct them as to where their concerns can be remedied. Otherwise, we put into statute something that already exists. They think they have new rights and are emboldened when in fact they have nothing more. So I do see it as a bit deceptive, and I'd like us to encourage parents to go to where they need to go to remedy the fact when they think their rights are violated.
Thank you. Anyone else? Representative Raymond.
Thank you, Mr. Chairman. First of all, I'd like to say I agree with Representative DeSimone about her analysis of the two bills, the compare and contrast. I think that the Cordelli version is more appropriate than the other version, the CACR 25. However, my concern is with the language on lines 5, 6, and 7. And that says, neither the state nor any political subdivision shall infringe on these rights without demonstrating that its compelling governmental interest as applied to the person is of the highest order and not otherwise served. Currently, well, we know that the highest order and compelling governmental interest is the absolute highest burden of proof that there is. So that is much higher than everything else. Earlier today, we had an attorney in here talking about the difference between a preponderance of the evidence versus, I forget what the other phrase was. And he was supporting changing it to a preponderance of the evidence because he felt like that was a more appropriate civil thing. This, we're now saying, instead of a preponderance of the evidence for DCYF to intervene in cases, we're going to say it has to be of the highest order in order for DCYF to intervene. My concern is, even though they've indicated in the line, this shall not be construed to apply to a decision that would end life or physically harm a child. My concern is this is going to interfere with DCYF's ability to assess and intervene in cases where there is suspected child abuse or maltreatment. I'm also concerned because the carve out is only for murdering your child or physically injuring your child, but it doesn't say anything about your other decisions that impact your child's health and well-being. So what if I was neglecting my child? What if I decided that my right to direct the upbringing, education, and care of my child was to tell my 14-year-old that they need to drop out of school and go to work full-time? Does the government have a compelling interest of the highest order to prevent me from doing that? The Supreme Court says no, we don't under that level of scrutiny. That's why, for example, Amish people in Pennsylvania are allowed to pull their children out of school at 14, even though Pennsylvania has a law saying that there's compulsory education until 18. So my concern is that we're bandying about these legal terms that we don't fully understand the ramifications of. And so unless there is some sort of amendment that would assure us that this would not open the door to trafficking, neglect, psychological or emotional neglect of children, I just can't support putting something in our Constitution that is not going to be in the best interests of child well-being.
The chair would ask if retired Supreme Court Justice, Chief Justice, and current Judiciary Chairman Robert Lynn would care to come up and comment on the narrow question of highest burden in lines 5 to 7 here. What does that give? What does that remove? If you would, sir.
Well, I guess what I would say is, I mean, it's certainly true that that is, compelling state interest is sort of the highest burden that that legislation would have to meet to survive a constitutional challenge. For example, if this amendment were adopted, and given the, I tend to think that the example given, I mean, there is a U.S. Supreme Court case dealing with the Amish children in Pennsylvania that says what she indicated. So that, I mean, that would seem to indicate that would not be a compelling state interest. But I do think, I mean, my sense is that having that standard is appropriate because parental rights are very, very important. And it seems to me that the state should be able to interfere with those rights only when it has a very, very important reason for doing so. And we all might say, we all might sort of individually question, is it really the right decision for Amish people in that example to say their kids can leave school at 14? I wouldn't make that decision. I suspect that most of you wouldn't either, but I guess I do agree ultimately with the Supreme Court decision. It is that it seems to me that, given the religious traditions that they have in that faith, that's, I don't think that the government should be second guessing that, however much I might personally not be one that would make that choice. So
does the rest of the sentence that say, and not otherwise served, give DCYF and OCA opportunity to intervene in some of the cases that are not murder that we could see happening?
Oh, sure, yes. I mean, yes, for sure. Certainly, it would seem to me that, I would not in any way, if this constitutional amendment were passed, I would not in any way say that prevents DCYF from investigating child abuse or neglect or any of those things. That would be my view anyway.
So that additional phrase perhaps would address what Representative Raymond's concern was with the words highest order.
Right. I think so. I mean, I would not, as I say, I would not in any way interpret that to mean that, for lack of a better term, ordinary child protective services, because I think those things are, of the highest order.
Any questions for you while you're up here? Representative Grossman.
Well done, Chairman. Well done. Well, it wouldn't prevent them from investigating, but would it prevent them from having findings?
Geez, I would think not. I mean, let me give you this example, which and again, obviously any of these things in the area of constitutional law, it really depends on the particular facts and circumstances. So it's hard to give this is the right answer. But for example, if this constitutional amendment were in effect, perhaps it gives more weight to a parent's claim that there's only so far the state can go in becoming kind of a nanny state. In other words, just to give an example, when I was a kid, and that's a long time ago for sure. But when I was a kid, I walked to school probably starting when I was, I don't know, maybe 6 years old or so. I'm pretty sure I walked to school when I was in first or second grade, and it was 3 or 4 blocks away, and in a I don't know if I'd call it. It wasn't center city, but it was a sort of a residential area of a city, and I did that along with all the other kids. Now I think there's some people might say that's abusive. That's too much becoming that you're letting your child have too much freedom too young. Maybe if this constitutional amendment were in effect, maybe it adds some weight to the parents' argument that it's my decision to decide whether when my child is old enough to be able to walk to school. That's the one example.
Representative Long.
Thank you, Mr. Chairman. So to that same point, would educational neglect be the same thing, and they would weigh more on the parent as to what the parent senses is the educational capacity of their child or lack of?
I mean, if you're saying would this constitutional amendment be weighed in the balance if it were in effect? Yes, it would. As I say, I don't think that it would mean that outside of the sort of Amish culture or maybe some other deeply historical religious kind of thing. I think if I just decided I want my kid going to work in the factory at 14 years old because education is very important, I would tend to say that the state would have their compulsory education laws would trump that view on my part.
Okay, thank you.
Thank you so much for your expert testimony.
Well, I'm not sure how expert it was, but whoops, sorry.
More? I missed your hand. Sorry.
I'm sorry. No, thank you. I don't have a question. I just have a statement.
Thank you.
All right, no problem. Thank you very much.
Representative Nelson with a statement.
Sorry, sometimes I have bad timing.
No.
As we've seen and heard regarding other constitutional amendment, CACR that are coming through our legislation, one of the things that I've heard from both sides is that our constituents and our voters find it important. So why don't we have them, give them the ability to vote? And I agree with that. And there was a Granite State poll conducted by the University of New Hampshire Survey Center recently that found voters are split on whether they generally support a parent's Bill of Rights.
CACR, I think would fall under this poll as well, 41 to 39%. But amongst parents with children in the household, support for the legislation is an overwhelmingly 58 to 22%. So I think that it's a great idea for us to ask the voters that if it's important to them.
And unlike last year when it was a bill, this is a CACR. The burden of proof or the burden of passage is much higher. Anyone else? You, Representative Long.
Thank you, Mr. Chairman. Yeah, just with respect to that, New Hampshire's not a referendum state, because what the voters vote on everything we pass here would be the scenario. And where were those numbers? The 58 to something.
Thank you for the question. Among parents with children in the household, the number is 58% in favor, 22% not in favor. In general, the numbers were 41 to 39%.
Was that a poll or?
It comes from the Granite State Poll, a States of Opinion project conducted by the University of New Hampshire Survey Center.
Okay, thank you.
Representative Petrino.
Thank you, Mr. Chairman. I might be confused, and so I ask sincerely, what new rights would parents get other than what they already have? I just need to know exactly what rights that parents don't currently have will this afford them. I think, if we put this on the ballot for parents, they're going to be like, yeah, sure, I want parental rights. Okay. What new rights is this going to give? I need to know that for myself so I stop asking this question.
Representative Grossman.
Thank you, Chairman. So we're children and family law, and of course parents would want a parent's Bill of Rights and all those things, but we're charged with protecting children. And this CACR does have some issues that could potentially have teenagers being trafficked. Psychological abuse, neglect. So we're here to protect kids and to make sure that we're protecting them. And this CACR has some issues in it that gives parents, I think, more rights, possibly putting children in harm's way.
And Representative, this is not Chairman Lynn's statement notwithstanding, that the statement not otherwise served means this is not hamstringing DHHS or OCA?
It's debatable. It's exactly.
Yeah, okay. Representative Gregg.
Thank you, Mr. Chairman. There's a lot in this, and it's hard to kind of gather the thoughts of all this. The first thing is that children are not property, and children do have rights as well. And I think the more that we push stuff like this, we take that away. And one of their rights is the right to safety. And regardless of what testimony has been, that they don't think that this is going to cause a problem, you have to look at parents and parents that that are good parents. I know that if my kids something's happening in school that I don't like, I'm the mama bear, and I'm going to say, you know what? No, that's my child, and let's talk about this. Also, sometimes I have conversations with my child and say, well, this is the bigger world, so let's have a conversation about how we handle these kind of things. There are many, many parents, regardless of people that think that this isn't or common or not, that think that they're really great parents, and they are in fact abusive. As a matter of fact, all of the abusive parents that I have spoken with, that I have met, have always said that they're good parents. They're just trying to get their kid in line. They're just trying to get their kid to be quiet. The lack of insight into what is abuse, the lack of insight into what is good parenting, is very, very interesting. I second Representative Petrano's point that something like this is just going to embolden the people, not that are good parents, that understand that they already have these rights, but the parents that view their children as property, that think that they can knock them into next week to get them to listen, that kind of stuff. So I have high concerns about the safety of children and the rights of children with something like this.
Representative DeSimone.
Thank you, Mr. Chair. I respectfully, and I emphasize respectfully, disagree, because we already have laws in place that are protecting the children from the parents who think that they're doing the right thing, but they're actually abusing the children. So the laws that protect those children from abuse and neglect will protect the children. Currently, there's very little discussion about the protection of the good parent. I'm looking around this room and I'm seeing parents who are good parents, and they have zero protection. This CACR should go out to our legislative body in each and every city and town and let them decide if they want us as the legislature to make this change and give them, the good parents, the protection that they deserve. Thank you, Mr. Chairman.
Representative Raymond.
Thank you, Mr. Chairman. I'm wondering what protection good parents need that they don't have right now. I mean, currently, if DCYF comes to my door as a parent, I can tell them to go away. And their only option is to go to court and hope that they have enough evidence based on the report to compel me to present my child to them. I mean, right now there is a high-profile murder case which DCYF unfounded several times because they didn't have that level of evidence in order to move forward, right? Good parents are already protected under the law. Anytime we create this enabling legislation, it doesn't impact those of us who aren't harming our children. It only impacts the parents who don't have the best interests of their children in their hearts. And those parents exist. When we talk about parents' rights over children's rights, we consistently affirm that we don't value the safety and well-being and the rights of children in this state. And again, I noticed that there is a cutout here, theoretically, and we don't really know until there's a Supreme Court case, for physical abuse or killing your kid, but it doesn't say anything about neglecting your kid. It doesn't say anything about being required to provide medical care to your kid when they're ill. It doesn't say anything about, not allowing your child to be unsupervised at length. It doesn't say anything about any of the other laws that we have or guidelines that we have requiring parents to meet the needs of their children. So under this, what we are doing is we are enabling people to have the right to say, I can do whatever I want with my child because I own them. And we're not allowing the state or our community values on what is appropriate for kids to have sway legally. And I worry about that. And I'm significantly worried about those kids, especially given that the Office of the Child Advocate report that came out on February, I think, 6th, said that there were 29 children under the age of 17 who died in New Hampshire last year. 29 kids. 1 was directly attributable to abuse. 2 were homicide. Several were overdoses, right? Maybe I think it's okay for my 13-year-old to smoke pot and do other things. Does this say that I'm allowed to do that? I don't know. I don't think we should wait for court cases to find out.
Let me say, and I hope also with all due respect, I fear the ever encroaching nanny state. You may not know, but in Oregon until some time ago, it was illegal to have your child in any school other than the public school. Now, I would say that is probably anti-Roman Catholic bigotry, but nevertheless, this is the state saying to parents, you cannot have your kid in a parochial school, and wow, you cannot homeschool your kid. And as I watch the polarization across the country, I fear ever overarching statism from the left and the right. And I'm suggesting that this before us is not so much parents versus children as it's parents versus an ever overarching state. So that is why I will be voting for this amendment. Anyone else? Representative Gregg.
Thank you, Chairman. If we really think that this is going to protect against abuse because of what we already have, before we start looking at something like this that will enable parents that are not good, can we look at what our definitions of abuse are and put some more safeguards for children in before we start to do this and give this to parents? That would be much more helpful. Right now, we don't even have an updated definition of abuse in this state.
Representative DeSimone.
Thank you, Mr. Chair. I'm reading and rereading the bill, and I don't see anywhere that it says in this CACR that the parents will own the child. The word's not used. That's number one. Number two, in the past, we have heard testimony time and time and time again where if you go to a particular public elementary, middle, or high school and ask for educational itinerary, you are denied access. You are denied. There is irrefutable proof about that denial. This CACR does not in any way, manner, or form allow a parent to become a criminal and abuse their child. It just gives them a constitutional right to be a parent. It gives them the right to go to a courtroom and say, I have never abused my child, yet I am not allowed access to my child. This is what it's all about. We have become a society that causes a CACR like this to become necessary.
I might point out on line 18, parents have the fundamental right and responsibility to direct the upbringing, education, and care of their minor children. The other bill, at least in its original form, had the word control. Among other ways, this bill before us, 17, is a much softer iteration of parental rights than the other one. Representative Petrino.
Thank you, Mr. Chairman. Along these lines, while I was driving in this morning, coincidentally, on the news, they reported a significant increase in measles among unvaccinated children. And it's because more and more parents are filing religious exemptions for personal philosophy and so forth. And the increase in measles is somewhat alarming, and it's rather new in a number of decades. So I just put that out there, that individual parents just don't believe in vaccinations, and right now we see a significant uptick.
Therefore, if this bill became law, would it mean that the state could not compel measles vaccinations of children? And would that be to be feared? Or put it the other way, should we allow the state to compel numbers of vaccinations of children? And that's kind of a crux issue here. Representative Perez.
Thank you, Mr. Chairman, for allowing me to speak. CR 17. We keep saying that we try to protect kids. To be honest, this is not protecting kids. this is taking away protecting kids. I've been saying it over and over and over again. As someone who was a victim when I was little, these two bills, it will take the protection of children from abusive parents. And I can tell you from the bottom of my heart that I'll be 50 years old in like a couple days, well, a week and a half. And the scars from the abuse when I was 5 years old until I was 10 years old, always gonna be on me. And every time this conversation comes out about giving more parental rights, when the parents already have rights, and then people don't have the answers when we ask what other rights parents want. When we allow them already to abuse children like myself. And I can tell you that I went to a Catholic school, and the Catholic school covered my dad's abuse against me because he was a big donor for the school to a private school. I can tell you that these two bills have nothing good about protecting kids. And it's not giving more rights to parents, abusive parents. Probably gonna give them more rights to continue doing the abuse without have a proper report or proper way to protect kids. So for that reason, I will say let's not support these two bills.
I think we're pretty well circling around and going over the same things again and again. Is there anything new that anybody wishes to say before we go to the vote? Representative Long.
One more. Thank you, Mr. Chairman. With respect to divorce cases, with respect to where parents don't agree, which one has that fundamental right? They both have the fundamental right. So I see job security for attorneys in the judicial system in this bill.
We'll now move to the question. The chair moves ought to pass. Do I have a second? Representative Nelson, I heard and saw. Next, Jay Nelson. I think we've discussed it to death, but I do have to give you the right to say anything more before we call the roll. Seeing no hands, the motion before us is on CACR 17. The motion is ought to pass, moved by the chair and seconded by Representative Jay Nelson. The clerk, please call the roll.
Chairman Pearson.
Yes.
Representative Long.
No.
Representative Disimone.
Yes.
Representative Bickford. Representative Nelson.
Yes.
Representative McMahon.
No.
Representative Connor.
Yes.
Representative Colcom.
Yes.
It's near Wales.
And Representative Seidel.
Yes.
Representative Grossman.
No.
Representative Levesque.
No.
Representative Petrino will vote no. Representative Perez.
Absolutely no.
Representative Gregg.
No.
Representative Fox.
No.
Representative Raymond.
No.
6-10.
The motion fails 6-10. The chair will entertain a second motion. Give it, ITL.
Mr. Chairman, I move ITL.
Representative Petrino moves ITL, and who is to second?
Second.
Seconded Representative Perez. Once again, I have to give you an opportunity to say something. Thank you for not doing that. The motion before us is ITL, moved by Representative Petrino and seconded by Representative Perez. And please, clerk, call the roll.
Chairman Pearson.
No.
Representative Long.
Yes.
Representative Disimone.
No.
Representative Bickford. Representative Nelson.
No.
Representative McMahon.
Yes.
Representative Connor.
No.
Representative Colcom.
No.
Representative Seidel.
No.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino will vote yes. Representative Perez.
Yes.
Representative Gregg.
Yes.
Representative Fox.
Yes.
Representative Raymond.
Yes.
Motion
Yes.
carries 10-6.
10 to 6, it carries. And would the clerk please write the report, which is handed to me, which I hand back to you, and I will take care of the minority report. This ends the exec session on CICR 17, and I'll now open the exec session on CACR 25. And I really don't think we're going to need a lot of discussion on this. But you may, if you wish.
Mr. Chairman, I will just put my 2 cents worth in and why I am not in favor, which is I don't have a clear feeling of where these CACRs are taking us. As Representative Petrigno stated, we've already got a lot on the book with the federal government and with the state government, and I guess I'm sitting here saying no one has articulated very well outside of the vaccination issue as to where we need to go. I usually say, what's the problem? Is this the solution? And I'm not clear on how much of a solution this is. That's where I'm at. Thank you.
Seeing nothing further, would somebody like to make a motion on CACR 25?
Move ITL.
ITL moved by Representative Long. Second, Representative Perez.
I move to second ITL.
Thank you. Any further discussion? In my opinion, and in the opinion of some of my caucus, committee caucus, this was the lesser of the two bills. So therefore, having supported in vain the previous one, I will be voting ITL against this one as well. Because that's kind of what we concluded last night, some of us, on my caucus. Anything else?
I concur.
Yeah,
Mr.
thank you.
Chairman, this bill has some dangerous language in it.
And after this is done, I've got to scoot upstairs to testify before a committee, but I will be back in case you're still here. Clerk, please call the roll. ITL is the motion on CACR 25, moved by Representative Long, seconded by Representative Perez. Clerk, please call the roll.
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative Tissimone.
Yes.
Representative Bickford. Yes. Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Connor.
Yes.
Representative Colcom.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino will vote yes. Representative Perez.
Yes.
Representative Gregg.
Yes.
Representative Fox.
Yes.
Representative Raymond.
Yes.
ITL passes 16-0.
Okay, and if you'd write the report, I'll look at it. This concludes the exec session on CACR 25, and it also concludes our meeting for today.